Let's get started. Sorry, here. All right. I apologize, I'm having a little PowerPoint issue here. There we go. All right. The current state of the economy. So let's start by acknowledging the current state of the economy, which is best summed up by this picture. As you will see, not only is this gentleman putting his head down because of the roller coaster ride he's been on with revenue dropping precipitously, but he also appears to have a mountain on his back. And many of you may feel the same way. Aside from COVID, which was going to inform much of this discussion, it's important to understand that most industries go through life cycles. Financial experts generally agree that a life cycle for an industry has 5 stages. And this is going to inform a lot of our discussion moving forward. So the 5 stages of a life cycle for an industry include stage 1, that's the introduction. And in this phase, the strategic objective is to achieve market acceptance and to seed future growth. In this stage, product innovation is at a maximum. The second stage is growth. At this stage of the life cycle, the growth rate of the market accelerates. An industry standard is often set during this stage. The third stage is a shakeout. And during this stage of the cycle, the growth rate declines and firms begin to compete directly with one another for market share, rather than capturing a share of an increasing pie. Weaker firms are forced out of the industry. Profit erodes, and only the strongest and most efficient firms survive as increasing rivalry in the industry as firms begin to cut prices and offer more services to gain more market share. The importance of process innovation increases while the importance of product innovation declines. Stage 4 is the maturity stage. And it's at this stage that only the few strongest firms remain and the industry morphs into an oligopoly with only a few large firms. Demand now consists of replacement or repeat purchases rather than a growing market. And the market has reached its maximum size, and industry growth is typically about 0 or even slightly negative. And then decline. This is the final stage of an industry cycle. And this is where market growth becomes negative as a result of changes to the external environment. Sorry, moving the PowerPoint again here. There we go. Where is the hemp industry? I would argue that starting around the 3rd quarter, the cannabis industry at large, including the hemp and CBD sector, began exhibiting signs that it was entering into a shakeout phase. And remember that there are a lot of overlaps, there's back and forth. These are not hard and fast lines between the different stages. But remember, the shakeout phase is when growth rate begins to decline and businesses begin to compete directly with one another for market share rather than capturing a share of an increasing pie. Weaker firms are forced out of the industry. Now, there will continue to be growth, and we'll talk about COVID in a moment, but it's clear that in some respects, we are heavy into a shakeout phase with the hemp and CBD industry. This apparent shakeout stage focuses on financial issues, including share price volatility, lawsuits involving company executives and claims of mismanagement, and most importantly, rapid declines in pricing. I think everyone on this chat probably has felt that. This hit the hemp industry particularly hard. Until the USDA's interim final rule was issued, the hemp industry was almost entirely regulated, or not, as the case may be, at the state level. And in fact, it remains that way since the 2014 Farm Bill pilot programs don't expire completely until October of this year. So there was no real national regulation or oversight or information. Since that was the case, the hemp industry evolved somewhat haphazardly with pockets of inefficiencies in the supply chain. And the price of hemp biomass and CBD isolate and distillate has dropped rapidly in the past year, and even high-grade hemp flour has seen some reductions in pricing. There's currently a glut of CBD products on the market, and consumers are definitely interested in these products, but you still remain confused and even put off by the lack of regulatory intervention, and they struggle to find good information. And I'm sure as anyone in this room can attest, a scammy hemp or CBD company with crappy products often looks the same or even better to a consumer that's simply Googling around trying to find the right product. All of this is to say that the hemp and CBD industry has been struggling with what is almost certainly a shakeout period with some regulatory issues. And then when the hemp industry was experiencing its first real financial struggles, COVID-19 hit and the world economy went, well, frankly, into the shitter. So with the exception of Zoom, which we're using right now, the toilet paper industry and maybe others, most industries are experiencing severe financial distress right now. This results in revenue reductions, which affects all aspects of business, from retaining employees to making capital improvements to sourcing inputs to marketing, etc. You may be having a cash flow crunch right now and may be struggling to pay your obligations in full. You also may be struggling to get paid from your vendors. Well, if that's the case, you are not alone. It's against this backdrop that I want to provide you with what I hope will be some helpful information. So, top 10 strategies for dealing with the cash crunch. I wrote an article about a week ago because I know that a lot of my clients are struggling with the cash crunch and wanted to advise them of some of the strategies and tips that I've picked up over my 20 years of dealing with companies and individuals who are in financial crisis. So let's go through them. Okay. The first tip is to obtain credit. Obtaining a line of credit or even a loan of a specific amount can help bridge the gap between the current financial insecurity and a future uptick in revenue. Now, there are obvious disadvantages to credit, including the requirement of periodic payments, the possibility of future default if cash flow does not improve, and of course, the likelihood of being required to sign a personal guarantee. Additionally, obtaining credit is difficult. Businesses in the hemp and CBD industry struggle, frankly, almost as much as the marijuana industry, to borrow money, and particularly from institutional creditors such as banks. Despite these issues, it's worth making an effort to obtain credit for smoothing out temporary cash shortfalls and to pay important vendors, and more on that in a moment. I will note that the Small Business Administration, the SBA, is offering disaster relief loans right now to qualifying businesses, and I'm going to discuss that shortly. Number 2, organize your accounting. Many businesses, of course, have dedicated financial personnel and their books are in tip-top shape. That being said, I continue to be shocked at how many companies' accounting practices and financial records are disorganized and, frankly, sometimes non-existent. The days of operating a profitable business in the hemp and CBD industry without a comprehensive accounting system and tight records is over. Admittedly, there was a short window of time, maybe a year or two, when rapid growth and the high profit margins in the CBD industry in particular and allowed businesses to succeed despite sloppy accounting practices. Be clear, those days are over. You need to take the time to organize your bookkeeping and your accounting system. This often means hiring a professional. Sorry, I went backwards instead of forwards here. So, review and cut your expenses. So once your accounting system is organized, you can easily create reports to see exactly how your business spends money. In my experience, there's almost always room to cut back, even businesses that are operating on a small budget. Now, this may include reducing redundancies, eliminating non-essential technology, consolidating and reducing physical workspaces, using less expensive inputs, temporarily reducing salaries, and identifying which aspects of your marketing campaigns produce measurable returns to avoid overspending on ones that do not. Create realistic cash flow forecasts. Another benefit of organizing your accounting is the ability to review accurate revenue reports in order to make reasonable predictions of future revenue. Now, admittedly, making cash flow forecasts in the present economic environment is particularly challenging, but even merely going through the exercise helps to create a realistic and sometimes dire expectation and can help you gain a better understanding of seasonal cycles and movements in your particular market. Number 5, prioritize your payments. Emotions and fear often drive how people choose to pay their financial obligations during times of stress. Unfortunately, this often leads to wrong decisions. I'm amazed at how often people forego their mortgage payments in order to remain current on credit card payments. And this is despite the fact that failing to pay a mortgage payment usually results in foreclosure of a person's home, while failing to make credit card payments does not. And this is almost always the result of what I call fear-based financial planning. And that is simply that since mortgage companies can usually get repaid just by selling a defaulting debtor's home in foreclosure, they don't usually, they do sometimes, but they don't usually resort to threatening phone calls or letters. On the other hand, credit cards and other unsecured creditors, by that I just mean lenders who are not secured by collateral, and we're going to talk about liens and collateral shortly. These unsecured creditors often use strong arm tactics, including persistent phone calls, nasty letters, and even outright threats to persuade people to pay them. And they use these tactics because they do not have the same level of recourse as a lender with a lien on a home or even a vehicle. So if your business does not have sufficient funds to pay all creditors in full, then the fact of the matter is you're going to have to choose which ones to pay. And this assessment of which ones to pay should be based on a number of factors, the most important of which include how quickly non-payment to a particular creditor can result in damage to your company. And that is not necessarily or even usually the creditor that, quote, barks the loudest. Number 6, negotiate favorable credit terms with your vendors, leases, suppliers, creditors, and so on. Now, this is crucial. Often vendors would prefer to grant temporary favorable terms to a struggling business rather than to risk default or losing the account altogether. And in the current economic environment, creditors are often willing to accept partial payments, extend payment terms, reduce interest rates, and make other adjustments to payment terms. For example, if rent payments are consuming most of your revenue right now, then ask your landlord for an abatement to be repaid in the future. And in fact, if your rental terms were negotiated during a time of abundance, then perhaps renegotiating the entire lease to reflect your anticipated future revenue is possible. But in short, do not hesitate to contact your vendors and propose modified payment terms. Some for sure are not going to budge, and it's likely though that you will be able to get some relief. And to that point, remember that your vendors may also be navigating their own difficult economic circumstances. And so to the extent possible, you want to propose a win-win solution. For example, a vendor may agree to accept prompt payments of a lesser amount rather than dragged out payments of the contracted amount in order to consolidate its position. Number 7, invoice quickly and offer incentives for prompt payment. You will rarely receive payment without sending an invoice. That's just a truism in business. And if you've already provided a service or made a sale, then make it a priority to go ahead and send an invoice. Given that most businesses are struggling with cash flow right now, it may be more beneficial to accept a prompt reduced payment than to hold out for full payment. This is just the corollary to what I was just speaking about. If you are a creditor right now and someone owes you money, well, it's important. You may want to consider taking payment now, the lesser amount, than dragged out payments over time. So to that end, offer incentives to quick payment. When cash flow is tight, it's just often more important to get paid a lesser amount now so you have cash reserves than a larger amount later. And it's particularly true, it's particularly true in times of global financial stress, like right now, when the company that owes you money may not even survive long enough to come up with the full amount. Number 8, focus on marketing and developing new business. It's definitely challenging to generate new business in a down economy. It's difficult to allocate limited resources to marketing campaigns and to developing new business. But right now, and despite this, now is the time to create or even preserve market share. Your competitors are going to fail, leaving you on top when times return, or they're going to succeed, leaving you with a smaller piece of the pie. Either way, and despite slim revenue and a deepening financial stress, it's vital that you focus on growth. Now, this does not mean a shotgun approach or like a see what sticks to the wall kind of a marketing approach. To my point earlier about cutting expenses, you need to cut out weak selling product lines and focus on promoting popular ones through targeted campaigns where you can see some meaningful returns and verifiable returns. So research and conduct studies to see where your market is, where it's going, and then apply your resources accordingly. Number 9, sell unnecessary assets. If your business owns assets that are underused and are not necessary to produce revenue, then you should consider selling them. If the goal is to survive a cash flow crunch, which it probably is right now for a lot of people in this room, then liquidating unnecessary assets can be the difference between surviving or failing. It's better to sell an asset now and use the cash to keep your business afloat than to hold on to it and risk it being liquidated down the road if the business fails. And of course, this totally presupposes a sober analysis of what the assets are that you need in order to keep in business and the ones that you can be sold without undermining it. But don't be short-sighted. Be willing to part with favorite assets that are not generating revenue. And finally, the top 10 tips for dealing with financial stress: consult with professionals, so attorneys, CPAs, and other financial experts. Now, here I am, an attorney, giving you tips, and I say consult with attorneys and other experts. So this may appear to be self-serving, but I can assure you that revenue spent on hiring an experienced professional to help with some or even all of the above comments that I've just mentioned and topics is money well spent. Your circumstances may require help with accounting, with taxes, with legal issues, negotiating with creditors, or some combination of the above. So take the time to determine what type of professional you need. Get references from your trusted sources, do online research, just like you would with any other product or service, and pull the trigger. It may truly be the difference between surviving the current crisis and being swept away in it. So with that, I'm gonna see, assuming that I can control the admin board here, if there are any messages yet. Let's see, or questions. I don't see any. That doesn't mean that there aren't any and I'm just looking at the wrong thing, but certainly feel free to send me messages. I'll probably hold off until the very end, but if it's pertinent to the topic at hand and I see it, I will be happy to jump in. Okay, so I'm going to move to the next part of my topic here and talk about the SBA. So to be clear, SBA help is available to the hemp industry. And I copied and pasted a little piece of the CARES Act that I'm going to talk about in a moment. But I think it's worth reading. Consistent with the Agricultural Improvement Act of 2018, otherwise known as the 2018 Farm Bill, a business that grows, produces, processes, distributes, or sells products made from hemp, as defined in 297A of the Act, is eligible for SBA aid. So the CARES Act, that is the law that we're going to be talking about, the federal law. I'm going to just provide a summary. I will say that this is a fairly deep subject with some very technical points. So feel free to follow up with me directly after this webinar if you have any specific questions, and I'll either try to answer them myself or connect you with someone that can. All right, let's talk first about SBA 7A loans. And I want to contrast them with PPP, the Paycheck Protection Program loans. So 7A loans traditionally are used as just low interest loans provided to small business owners as a lender of last resort. And these have been around for a while. This is not COVID specific. They're designed to be directly administered by lenders. In other words, you go to your bank and apply for an SBA loan, and they are managed and administered through that local bank. And importantly, they're designed to be repaid. They are in fact true non-forgivable loans. On the other hand, the Paycheck Protection Program, the PPP 7B, SBA 7A loans are specific to the COVID-19 economic harm. They utilize the SBA's partner banks and lending institutions, and they are designed to be substantially forgiven. And that is a very crucial piece as we're moving forward when we're talking about money and money that's available to your business. The fact of being able to get a loan that is actually a forgivable loan that amounts to, in a lot of respects, free money is really important. So let's look at how PPP loan amounts are determined. And by the way, while I'm talking about SBA here, I want to give call out to Chris Davis and Tom Bowden. I did a webinar earlier this week about financial matters with respect to lawyers, and they were co-panelists, and they provided some great information on SBA issues, and I am with their help have been able to put together some of these slides for you. So thanks again to Chris and Tom. Okay, how PPP loan amounts are determined. It's fairly simple formula. It's the average monthly payroll cost times 2.5, and then plus any outstanding SBA 7B2 loans, which I'm going to talk about in a moment. So if you're a business that does not have an SBA 7B2 loan right now, then it's just your average monthly payroll cost times 2.5. If you already have a loan with SBA under 7B2, you would also add that amount. And then it's just the payroll cost as far as from a definitional standpoint. It can encompass several things. It can encompass the salary, wage, commission, or similar compensation, payment of a cash tip or equivalent, payment for vacation, parental, family, medical, or sick leave payment, or benefit, allowance for dismissal or separation, payment required for the provisions of group healthcare benefits, including insurance premiums, payment of any retirement benefits, or also payment of state and local tax assessed on the compensation of employees, and the sum of payments for any compensation earned, income of a sole proprietor or independent contractor. So there's a formula, and you would want to work with your financial person to make sure that that formula, that you apply it properly. The next subject would be the PPP loan amounts and the allowed usage. So the amount of the loan is determined by the formula I just described. And it has certain allowable uses, and that is you can use it for payroll costs. You can use it for mortgage or rent payments, although notice that only the amount paid on interest may be forgiven, which I'm going to talk about in a moment. It can be used for utilities and debt obligations that were incurred prior to February 15th of this year. And again, only the interest portion may be forgiven. So these are the allowable uses that you could apply, that you can apply the loan funds to. On this next slide, I want to talk about the allowable use versus debt forgiveness. So on the left hand, we see the allowable use. We've got payroll costs, mortgage and rent payments, utilities, and debt obligations. On the other hand, those don't always track as to what specifically is going to be forgivable. And that is the payroll costs, interest on mortgage or rent payments, and certain utilities. And what the SBA says is that at least 75% of the forgiven amount must be used for payroll. So all that is to say that there are, you can apply for a PPP loan if you're eligible. The formula is your payroll plus times 2.5 plus the amount of any SBA 7B2 loan. And there are allowable uses. Some of those allowable uses are forgivable, meaning that that portion is free money. And so when you are looking at these loans, and particularly if you get the money, it's important to make sure that you're using them for allowable purposes, and you really probably want to be using them primarily, if not entirely, for forgivable uses. And as a last little piece on that before I move to the next slide, this money cannot be commingled and has to be traced. And so if you're applying for an SBA loan, I have been told that it's important that you open up a separate bank account that is solely for these SBA loan proceeds. The last thing you want to do is apply for the loan, get the money, put it in your general operating account, do all the right things, and under all reasonable circumstances, you'd be able to get full debt forgiveness, but then not be able to get any debt forgiveness because you have commingled the funds and haven't been able to show which funds the loan funds were used for versus your normal operating funds. So that is, get a separate bank account, open a separate bank account for these SBA funds. Okay, a little bit more on the SBA, the idle loans and grants. And again, thanks to Tom and Chris for this information. SBA 7B2 loans are traditionally used as low interest loans provided to disaster areas. They're designed to be directly administered by the SBA. They're also designed to be repaid. And I've got a link there if you need to go review that. The idle grants are specific to COVID-19 and economic harm, and they utilize the SBA's direct lending infrastructure to provide the grant. And they are designed to be unpaid and forgiven. And so there's a link there. So that's the section on SBA. And now I want to move forward to Debtor Creditor Law. I'm going to give a primer on it. And I'm going to address the following. First of all, that the US is a federal system, and that has some ramifications for debtor credit law. Second, I'm going to talk about debts and claims and what they are and how to think about them. I'm going to talk about the enforcement of claims, which is applicable whether someone is trying to enforce a claim against you, so you know what the process and options are, or whether you're trying to enforce a claim against someone else so that you know what your options are. And that is the demand, a lawsuit or litigation, the impact of liens, collecting on a judgment. And then finally, I'm going to talk about bankruptcy, because I think that in post-COVID, we're going to see lots of bankruptcies in general. And I want to talk about how that's going to potentially impact the hemp industry. Okay. I do have a question. Is this online, or can we get this PowerPoint afterwards. So as I understand it, I am recording this, by the way, and I think it will be available by the HIA. You can also email me directly. I'm more than happy to share this PowerPoint. I'm also more than happy to speak with you about your circumstances. Okay, federalism. So as most people know, the US, like Germany and lots of other countries, is a federal legal system. And what that means is that we have a national government, and then we have 50 state governments, and also we have Indian tribes and US territories. And so within this matrix, there are a lot of overlapping legal issues, laws, and regulations. And this is what lawyers call federalism. And I won't go down a rabbit hole on this particular webinar, but federalism is an issue that we in the hemp and CBD industry are dealing with daily. You know, we've got the 2018 Farm Bill and the USDA. Then we've got all the different states and their plans and their laws. We've got the FDA and its views and positions on CBD. And then we've got the various state departments of health and departments of agriculture and their particular views, all and what laws and what governing bodies control and what happens when they are when they conflict with their regulations and laws, which laws prevail, and so on and so forth. All of this is federalism and is not new to the hemp industry. But it's also important with respect to debtor creditor law. And that's because it's very important to note that with the exception of some consumer protection laws and bankruptcy laws, bankruptcy is a legal proceeding that I'm going to talk about in a moment, which is filed in federal court. With those exceptions, debtor creditor law is mostly state specific. And in fact, many provisions in the federal bankruptcy code authorize states to opt out and superimpose their own laws. And that is, so a state is superimposing its own laws in a federal court proceeding. So for instance, if someone files bankruptcy in California, they actually may be subject to a number of different laws and rules than someone who was to file bankruptcy in North Carolina. And what this all means is that where you operate, where you live, where you source your inputs, where you sell your products, and where you incur debt can greatly affect your legal rights and responsibilities. I'm going to stress that again because I think it's important. Where you operate, live, source your inputs, sell products, and incur debt can greatly affect your legal rights and responsibilities. So I'm going to be discussing in general terms, what to do with respect to debts and claims, since the federalism issue alone is the subject of many detailed and many would say boring legal books. My goal is not to give you a primer on or anything in depth on federalism, but just to give you an overview. And I think it's important to note that state-specific laws and regulations are going to control more often than federal laws. So let's talk about debts and claims. For our purposes, we're going to use the term claim rather than debt because it's broader and more general. A debt typically refers to a loan that is owed by a debtor to a creditor, such as from a processing facility to a bank or an equipment finance company that's memorialized in a promissory note. So if that's, your traditional loans are typically referred to as debts. On the other hand, a claim includes debts, but it broadly refers to any assertion by one party against another, contending that that other party owes it money. So a claim, again, is broadly referring to any assertion by party A that party B owes it money. So this could be a debt pursuant to a formal loan and a promissory note, but it could also mean an investor contending, for instance, that the company she invested in was improperly operated and that she's owed money for malfeasance. A claim could be an employee claiming back wages. A claim can be a consumer suing a company based on allegations that it misstated its CBD concentrations on its products, or a claim could be from a vendor that it hasn't been paid for its products. In other words, any time that someone contends that someone else owes them money, that person is asserting a claim. Now, I think it's really important to note that just because someone asserts a claim doesn't mean that that claim is valid. That's just the terminology that we use. It's simply an allegation. Okay, let's talk about enforcing claims. I note that someone asked a question about the idle loans. I'm going to circle back around and answer those questions just so I don't muddy the waters on the enforcement of claims and legal proceedings right now, but I'll answer that at the end. Okay, enforcement of claims. Generally speaking, there are several ways to enforce a claim. And I'm going to lump these in broad categories: demand, a legal proceeding or lawsuit, lien enforcement, and then collecting on a judgment. Let's talk about demand. So a demand is a very general term. A demand for payment can be made verbally. If you call up the person who owes you money on the phone and say, I demand that you pay me. That's a formal demand. But more likely than not, particularly in the business and legal world, it's by what's called a demand letter. And that is where it's a formal letter stating, you owe us a claim, here's why, here's the amount, and we demand payment within a certain date, or we're going to take further action. So most contracts contain provisions regarding what happens when a party has breached the agreement. So this can take the form of formal notice requirements, such as a demand letter that I just mentioned. It can also take the form of opportunities to cure the breach, such as maybe providing additional time, required mediation or arbitration proceedings, and it can also provide which courts and sets of laws have jurisdiction over the parties. Some claims are not memorialized by a contract, though, but by laws themselves. For instance, someone alleging that a company's CBD marketing deceived them, or an employee asserting a claim for unpaid wages, those parties who assert claims may not have contracts they're relying on. Rather, their claims are based on a specific statute. The consumer who's alleging fraud is going to rely on state and federal fraud and unfair business practices laws to support their claims, and may even rely on federal labeling laws. The employee is going to rely on state labor laws regarding the payment of wages. So to be clear, when you make a demand, it can be by verbally or by a letter. It can be based on a contract itself, in which case the demand usually has to comply with the contract terms outlining what a demand is and what rights the other party has to cure or make up payments. But a claim or a demand on a claim can also be made based on other factors, such as someone alleging that a breach of a law caused them harm. So additionally, claims are sometimes based on communications and the course of dealing between the parties. So a supplier, for instance, may not have a contract with a vendor, but if it's routinely supplied a product for a specific price to a company and then suddenly was not paid, that vendor can rely on verbal and written communications to establish that a contract was formed, and can also rely on the fact that it was engaged in a common course of business dealings with this other company and wasn't engaged in a charity when supplying to the company. So in other words, a claim can be made, can be based on a number of different factors. Under all of these circumstances, the party that has a claim can make a demand on the party that it contends owes it money. So when doing so by the demanding party, it's usually best to reference the nature of the claim. This is an unpaid loan. This is for unpaid wages. This is for unpaid product, or whatever the claim is based on. You should include or reference any documents that support the claim, whether they be a promissory note, email communications, letters, etc. You should identify the actual dollar amount that's claimed and the basis for arriving at that claimed amount. So just to summarize a demand, when making a demand, you should reference the nature of the claim. What is the basis of the claim? Unpaid loan, unpaid wages, etc. You need to include or reference any documents, the notes or communications that support your claim. You need to be asking for a specific dollar amount, and you also need to provide the basis for that. So if you're asking for $1 million, you want to show that that's not a number that's pulled out of the air, that's based on calculations and based on what you think that you might be able to receive if this matter went to court, which is our next slide. So if a demand does not work, if you make a demand on another party and they do not agree to pony up the money, or a party makes a demand on you and you don't pony up the money, a lot of times my clients say, okay, well, what's the next thing we can do? And I say, well, we can file a lawsuit. Because there's nothing to force someone to do something in most circumstances to pay you. And so you file a lawsuit. And by this, I mean broadly, any sort of legal proceeding. And this happens when a demand has been made, but payment has not been met. So for instance, a bank may send a demand letter to someone who's delinquent on a loan. And if the debtor, meaning the person who owes money, does not pay the bank after some period of time, the bank will usually file a lawsuit, and it will allege breach of contract. Similarly, the consumer that I've mentioned who claims that a CBD company defrauded him, and the employee who claims that her employer owes back wages may also file lawsuits if their demands are not met. That being said, lawsuits are usually long. They're complex and can take years. Even simple lawsuits can take up to a year. They're also usually expensive, time-consuming, stressful, and hyper-technical. It can be very easy to screw up a lawsuit and not win, even if you otherwise have a right to win. And most litigants, and that means most parties to a lawsuit, never see a jury. And I think this is important. Contrary to popular belief, you're not necessarily entitled to have your day in court. And so what happens is, in a lot of circumstances, a client will come to me and they'll say, you know, party X owes me money. And I'll say, great, let's send a demand letter. We send a demand letter. The other party, after negotiations, won't pony up the money. And my client will say, okay, well, what's next? And I'll say, well, we could file a lawsuit. And they say, great, let's file a lawsuit. And I talk about the lawsuit and what's involved. And they say, well, no, I don't want that. Let's just, what else can we do to get the money? And I say, well, a lot of circumstances, that's it. And so I think it's important to note the difference between a demand and a lawsuit, and to note that lawsuits can be very effective and are often necessary, but they are also time-consuming, complex, stressful, expensive, and it doesn't always mean that you win. And I'm going to talk about what happens if you do in a moment. But before I do, I want to talk about lien enforcement. A security interest, or a lien, is when a party holds rights in collateral to secure payment of a claim. The most common lien that most people think of is with a home mortgage and a vehicle for equipment financing. In those cases, the lenders, usually the bank, holds a lien in the real estate, the vehicle, or a piece of equipment to secure payment. And if the payment's not made, the lender can repossess or foreclose the collateral. So if the borrower who lives in the house with the mortgage doesn't pay, the bank's going to foreclose. If the equipment supplier isn't paid and has a properly perfected lien, and I'm not going to go into lien perfection and all the technical details on this webinar, but assuming there is a proper and enforceable lien, the supplier can go and repossess that equipment for non-payment. These types of liens are called consensual liens, and that's because the parties agree to it. In other words, the person borrowing the money to go buy the house agreed that the bank could put a lien on the house to secure its interest. And that's pretty normal, because the bank would just say, well, no, we're not going to loan you the money unless you give us a lien. And that's pretty common. And so, but this is a negotiated for deal. It's called a consensual lien. But it's also good to be aware that there are also non-consensual liens. And what that means is that the party on whose property a lien is placed did not consent to it. In fact, instead, the lien is placed or operates as a matter of law. So for instance, in some states, a court judgment acts as a lien on real estate owned by the debtor in the county where the judgment was entered. So for instance, party A may sue party B and win. And party B may own a house in the county in which the lawsuit happened. And if that's in North Carolina, for instance, a state that does this, that judgment automatically attaches as a lien to party B's real estate. It doesn't attach as a lien to vehicles or any other personal items, but just to that real estate. And again, this is very technical. It doesn't apply to real estate in other counties, and liens can sometimes, judgments can be transferred to other counties where they would attach as a lien. Again, it can get very technical and in a thicket of legal details very quickly. But the bottom line is that there are liens that operate as a matter of law. Another type would be a construction lien, and that applies to secure payments to contractors who work on a piece of property. They can get a lien on that property that's non-consensual if they're not paid for their work. In that case, it's based on law, but they have certain things that they have to do, timely filing lien documents in order to preserve their rights. Additionally, landlords often have liens on a tenant's property that's located in the leased premises. So if the tenant stops paying and the landlord gains possession, any items that were behind, sometimes in some states, in certain circumstances, will have a lien on those items and can sell them to try to satisfy the debt. Lien law is very fascinating, believe it or not. Some would say dry, but it's also very technical. It can be extremely helpful when you're negotiating on the front end for your contracts. It can also be very helpful to know lien law when you're performing services somewhere, so that you can get your, understand how to get your debts paid. And if your collateral is subject to a lien, it's also really important to understand lien law so that you know how to protect it and what items that you might own are actually collateral. Let's move on to collecting on a judgment. And I will say it right at the outset, there are entire legal education programs where lawyers spend a day or two learning how to collect on a judgment. And that's because a judgment, and that's where party A takes party B to court and wins the lawsuit and gets a judgment. That does not mean the judge looks at party B and says, all right, write a check or you're not leaving this courthouse. It doesn't work that way. A judgment does not usually mean that the entire debt is automatically paid or even has to be paid within some prescribed time. If you're owed a judgment, you usually have to take action. And that's often with the local sheriff's department or a debt collection agent. So if you owe a judgment, in other words, if you're party B and someone has sued you and gotten a judgment, that may be very bad, but it doesn't necessarily mean that you have to stroke a check right then and there. You may be able to use the law to slow down or reduce the amount that you owe. So for instance, if you own no property of value, someone sues you, gets a judgment for $1 million, but you don't own much and you have a small amount of wages, then you're what lawyers call judgment proof. And that means that despite the fact that there's a judgment, it's going to be impossible to get you to pay that debt. And if that's your situation, you may decide just to hang back and deal with the calls and the letters and everything else and not pay, or you may decide that you're going to negotiate for a smaller amount despite the judgment and the fact that the judgment is for more. And I hope this is clear, and I think it's worth discussing a little bit more. So let's say you're party A and you sue party B on a contract for $1 million and you win and you get a judgment and you go to party B and you say, all right, I want a check for $1 million. And party B says, I can't pay $1 million. In fact, I'm not going to pay anything. And you get really frustrated, understandably, because you were owed money. The courts said that you're owed money and you paid lawyer fees and went to court and spent 2 years litigating, and now you've got your judgment. You want your money. That's very reasonable. But party B may not have the ability to pay and may not have assets that you can liquidate to pay. And so you may be stuck. In that situation, party B may say, you know what, I tell you what, I can borrow or get my hands on $100,000 or $500,000 or $750,000 or some amount of money. And if you're satisfied, that's all that you're ever going to get, at least without spending lots more in time and legal expenses, you may accept that. You may say, you know what, fine, I will accept $600,000 on my $1 million judgment because I know that's all I'm ever going to get, and it will close it out. And similarly, if you're party B, just because there is a judgment against you, you may be able to negotiate better terms depending on your financial status. Okay, insolvency. I'm going to address receivership and bankruptcy. Generally speaking, insolvency is when a company cannot meet its financial obligations. And there are two types of insolvencies: cash flow and balance sheet. In cash flow insolvency, the debtor, meaning the company that owes money, suffers from a lack of financial liquidity, making it impossible to pay the debts as they fall due. That's a real technical way of saying that there's not enough money to pay the bills. So a lack of financial liquidity means not enough money to pay the bills. And this is the type of insolvency that most individuals experience in small companies prior to filing for bankruptcy. The other type of insolvency is balance sheet insolvency. And that is when there are negative net assets. In other words, when the value of all of a company's assets are less than all of a company's liabilities. And that's where, let's say a company owes $1 million, but all of its equipment and receivables and everything else of value might be $300,000. It is a net negative of $700,000 insolvent. So this is the form of insolvency that's normally described by corporate entities filing bankruptcy. Let's talk about receivership real briefly, and then I'm going to talk a little bit more about bankruptcy. And then I'm going to answer some questions. Okay. Receivership. This is a state court action to administer a business's assets to creditors in an orderly fashion. And I'm not going to go into much detail. I'm only mentioning it here as every state has its own receivership laws. Typically, receiverships are initiated by a company's creditors in order to exercise control over that company's revenues and assets and to avoid improper uses of money, liquidations of assets, and fraud by the owners. In a receivership, a court will usually appoint a receiver, that is often a lawyer or a CPA, to manage the company for the court on behalf of its creditors. and that's to ensure that they receive the most that's available and that the distributions to creditors are fairly apportioned under state law rules. So in many respects, receiverships are very similar to bankruptcy, which is a federal court proceeding, and which is I'm going to spend the rest of my time today discussing. I have a question on how do you become judgment proof? I think that's worth stopping for a second. That's a great question. So judgment proof means that someone is unable to, or a judgment is unable to be enforced against someone. And so how you would do it would depend on your own circumstances. Generally speaking, it means that you do not have sufficient assets or income to pay the debt. So the best way to be judgment proof is not to have anything. But there are, and we'll talk about this a little bit in the bankruptcy context, there are assets that you can own that are exempt from execution. So for example, most qualified retirement plans are exempt. It may be that you rent an apartment, you lease a car, you've got, a desk, 2 chairs, and a mattress on the floor. You have very nominal income, but you have $500,000 in a retirement account. In that situation, under most state laws, because remember, debtor creditor law is mostly state specific, you would still be judgment proof despite the fact that you had an asset worth $500,000, and that's because your retirement plan was exempted. There's also different types of ways for owning real estate, for instance, and this is also very state specific, and I'm going to avoid going too far down the rabbit hole. But in many states, when a married couple owns real estate, they own it as what's called tenants by the entirety. So it's a legal form of property ownership. In those circumstances, if one party to the marriage, say the husband, owes a debt, but the other party to the marriage, the wife, does not, well, then that creditor may not get a lien or execute that judgment against that person's real estate. So although the husband does own an interest in that real estate, the creditor can't get it because the tenancy by the entirety protects it. So there's all types of exemptions and ways to go about being judgment proof. That being said, there are also laws that will allow certain transactions to be undone. They're called preferences. And so example, if you had $1 million in the bank and someone got a judgment against you and you transferred that $1 million to your mother, that creditor could sue your mother to recover that. So getting judgment proof is not so easy necessarily as just getting rid of your assets. I'm gonna circle back around and talk about that in a slightly different context, but that was a good question. Another question about what other kinds of exemptions are there? I'm gonna hold that question and again wrap it into the bankruptcy. So bankruptcy. Bankruptcy is a legal proceeding for eliminating or managing debts of an insolvent person or company and for providing an orderly payment to creditors. I'm gonna say that again. Bankruptcy is a legal proceeding for eliminating and or managing debts of an insolvent person or company and also for providing an orderly payment to creditors. I think a lot of people throw around the term bankruptcy. Oh, I'm bankrupt, or that company's bankrupt. And that we use that, but usually what people mean in that scenario is that person or company is insolvent. Bankruptcy itself is a very specific legal proceeding. It's something that is filed in a federal court. So someone is actually either bankrupt or not based on whether or not they have filed a case. And I'm going to talk about how these go. There are voluntary bankruptcy cases where people will file bankruptcy themselves. A company will file bankruptcy. There are also involuntary bankruptcies where a company's creditors will put that company into bankruptcy. That may seem like, why would creditors want a company in bankruptcy? But it usually has to do with putting a company under a court's directives so that the company doesn't spend money unwisely, or so that assets aren't liquidated and disposed of outside the reach of creditors, so that creditors can have some management and control over the liquidation or reorganization of that company. And in fact, there are several different key aspects to bankruptcies. And I'm going to just talk generally about bankruptcy and roll in these concepts, but it's important to understand the automatic stay, that there is a liquidation bankruptcy where the court, actually a trustee in court, sells a debtor's assets. There are also reorganization or repayment bankruptcies for individuals and businesses. There is an individual called a trustee that administers cases for the court. There is an estate, which encompasses the assets of a debtor in the bankruptcy court. There are exemptions, which are assets that individual but not business debtors can take advantage of to protect some of their assets. And there are also claims that are classified and disbursement of funds to creditors. So I'm going to talk about all this. And so let me start by saying, again, I practice bankruptcy law for 20 years. And generally speaking, what I would tell people is that bankruptcy is a process for getting rid of or managing debt. The way it works is that a business or an individual called the debtor will complete a bankruptcy petition. And the bankruptcy petition is a full disclosure document. It lists the name of the debtor, the addresses, all of the assets, everything from intangible things like receivables and tax credits, all the way down to very tangible things like real estate and pieces of equipment, money owed, money in the bank. It lists all of the creditors. So you cannot omit a creditor. You have to list all of the financial obligations that are there. You list detailed expense and income receipts and projections. And then the last part of the petition is a long series of questions asking about very specific things like, what have you been sued? Name all the lawsuits within the past 2 years. Name all transfers of assets outside the ordinary course of business within the past 2 years. Name all repayments of debts to certain creditors, and so on and so forth. The bottom line is, in order to initiate a petition, whether voluntary or involuntary, or initiate a case, a bankruptcy case, a petition is filed, and that petition is a full disclosure financial document, and it is a public document filed with the court. Once that document is filed, the court will issue what's called an automatic stay. The automatic stay is an injunction. An injunction is a court order that simply says that the court prevents someone from doing something. In the case of the automatic stay, it's an injunction that goes into effect immediately upon filing the petition, and it stops all collection activity against a debtor. So a lot of times people will be right at the point where they're about to get a judgment filed against them, or their house is about to be foreclosed on, or they're getting lots of phone calls and letters. Whatever the case may be, they're getting all sorts of actions for creditors are trying to enforce their claims. They file bankruptcy, the automatic stay goes into effect, and it automatically and immediately stops all of that activity. It stops the lawsuits, it stops the foreclosure, it stops the creditor calls. It usually, in most instances, stops even the IRS from its collection activities. And at that point going forward, all collection has to go through the bankruptcy court. There are essentially two types of bankruptcies. There's all sorts of different chapters for different types of debtors, but when you boil them all down, there are two types of bankruptcies. There's a liquidation bankruptcy in which the debtor's assets are liquidated. So if they have cars and trucks and real estate and money in the bank, all those assets are sold. They're put into a pool of funds, and then those funds are called the estate, and the estate is distributed to creditors in a fashion that we'll talk about here in a moment. That's liquidation bankruptcy, and it is Chapter 7 of the Bankruptcy Code. So if you hear about someone filing Chapter 7, what they've filed is a liquidation bankruptcy. It is not a repayment plan bankruptcy. All of the other types of bankruptcies, whether it be Chapter 9, which is for cities, Chapter 13 for individuals, Chapter 11 for businesses, Chapter 12 for family farms, all of those bankruptcies are some form of a repayment or reorganization. In other words, the debtor may, under certain circumstances, liquidate some assets and that money get paid to creditors, but by and large, they are entering into some sort of a repayment plan that is different from the contractual terms or the legal terms they were required to pay prior to. So Chapter 13 for an individual is a 5-year repayment plan. They pay back a percentage to their creditors over that 5-year period of time. In a Chapter 11 reorganization, for whether it be airlines or a small real estate company, what they will do is they will usually decide what assets they're going to liquidate. They'll also renegotiate through the bankruptcy process certain claims against them, and then they will propose a plan that the creditors can vote for, believe it or not, as to whether or not they can proceed. So they'll liquidate the assets, distribute the proceeds, and then begin making payments on the new debt. And again, you may say, why would creditors ever voluntarily participate in this at all? And the fact of the matter is that bankruptcy is actually, particularly corporate bankruptcies, are designed for the benefit of creditors, not so much for the debtor. In other words, the business is put before the court, and it cannot do anything without the court's authority. So the assets are protected in that respect. A lot of times the creditors will agree to take a smaller amount of their debt over some period of time in a bankruptcy because they are assured of receiving it through the court process than continuing to try to step in line with other creditors and sue and spend lots of money trying to collect it outside of bankruptcy to collect more. It's that same thing that we were discussing with the 10 strategic steps. Sometimes it makes more sense to take less money under certain circumstances than it is to wait or fight for more money. And that's an oversimplification, but it's kind of how bankruptcy works with creditors. It gives them some predictability. And so a lot of times they're willing to take less than they would otherwise be entitled to under the law. So those are the types of bankruptcies. In a bankruptcy proceeding, under most but not all cases, a trustee is appointed. And a trustee is sort of like the receiver in a state court action. The trustee is usually a lawyer, but not always. It can be a CPA or some other official that is responsible for overseeing the debtor's activities, investigating the debtor's financial position, and then also, particularly with liquidations, is responsible for actually doing the liquidating of the assets, maintaining the funds in a trust account, and then evaluating the claims, which I'm going to talk about in a moment, and then paying those claims out based on liquidated assets. Before I talk about claims, I want to talk about exemptions. Exemptions are what I was just mentioning when I was talking about, for example, certain types of retirement accounts. An exemption is when an asset would normally be an asset that would be liquidated, but because of the type of asset it is and the laws that apply, it is protected from liquidation. In most, but not all states, and remember I said the bankruptcy laws allow states to opt in and impose their own laws. So exemption laws vary from state to state when you file bankruptcy. Certain states allow you to exempt all or a portion of your retirement account. That is an exemption. Usually states will allow a certain amount of equity in a vehicle to be protected. Certain states will allow a certain amount in sort of regular household goods to be protected, and so on and so forth. So to the extent that you're an individual, it helps to make sure that you're maximizing your exemption so that you can keep as much as you want or need, I should say. And then the rest, the trustee has an obligation to sell, to use that money to pay the creditors. In reality, and in my experience over the years, I would say that probably 90% of Chapter 7 cases were what we call no asset cases. In other words, after a debtor had exempted all the assets to which he or she was entitled, there were no assets to be distributed. And so that case just closed and creditors didn't receive money. It's only in the cases where there are substantial assets that creditors usually receive money. Creditors getting money, what they have to do is, remember that the automatic stay goes into effect when a petition for bankruptcy is filed. And that automatic stay prevents normal collection activity. So now they have to go through the bankruptcy court. And what they do is they receive a notice from a bankruptcy court that a debtor has filed bankruptcy. And they say, the person that owed me money filed bankruptcy, or the company that owed me money filed bankruptcy, and I want to get paid. So they file what's called a proof of claim with the bankruptcy court. And the proof of claim sets forth who that creditor is, what they allege is the claim amount, any supporting documents for that claim, and what priority they are. Meaning, are they a secured creditor that has collateral in the debtor's assets? Are they unsecured creditors? Some creditors are called priority creditors because they are unsecured, but they have a priority status over other types of creditors. The IRS, as you might imagine, has most types of tax claims have priority status over regular debts. But there are also other types of priority claims, such as payments for certain wages, payments for child support, and things like that. So as a creditor, if a company that owes you money files bankruptcy, one of the first things you want to do is decide whether or not you're going to file a proof of claim. And if so, they're fairly straightforward, but you might want to consult with a lawyer on how to do that. And what that will do is, if there are proceeds to be distributed, then you will be given your pro rata amount. It may be 2 cents on the dollar, it may be 80 cents on the dollar, or it may be full payment. It all depends on the debtor's status. And the final piece that I'm going to say is that businesses themselves are not entitled to exemptions. And so a company that files bankruptcy, all of its, under Chapter 7, all of its assets will be sold and the proceeds paid to creditors. A company that files Chapter 11 may not have to liquidate its assets if it proposes a plan of reorganization that's approved by the court and by the creditors. And then finally, the last concept that I didn't even write, and it's probably the most important one, is a discharge. And so a bankruptcy, the net result of a bankruptcy after payment to creditors of any amounts that they're owed and that were collectible in the bankruptcy case is that the debtor gets a discharge. And so if a person files bankruptcy, once they're done, they no longer owe the debts. A business files a Chapter 7, it actually dissolves that business, and that's done. A business files a Chapter 11 reorganization, it gets a discharge of all debts that were incurred prior to it, and the new proposed plan payment is the new debt going forward. And the last little piece I'll say, because a lot of people immediately think, well, if I can get rid of my debts, I'm going to file bankruptcy and not have to pay my mortgage anymore. Well, liens typically are not affected by bankruptcies. And so even though you may not owe your mortgage company more money, if you file bankruptcy and don't pay them, they can still foreclose on your house. They might not be able to sue you personally for the debt, but they can get your house. So that's a question I used to get quite a bit. All right, that is bankruptcy. What I'm going to do is turn on the video again. Let's see. Hello. And answer your questions. It was a lot of information, and I hope that it was clear, but certainly I'm happy to answer any questions, any follow-ups. And while you're writing, I again want to thank the HIA for having me and for letting me put on this webinar. You know, unfortunately, this is a tough time for most people. I think most people and most businesses in the hemp and CBD industry and in a lot of other industries right now. And this recessionary time will pass. But in the meantime, there is a lot of financial struggle and a lot of financial crisis. And there are, sorry, someone asked, put my information up. There we go. And there are a lot of things that you can do if you owe money or you're having a financial cash crunch that will help you to survive it and to move forward. And again, if you're owed money, there are a lot of things that you can do to try to collect on that money. And so I think it's important to recognize these options and to reach out. Looks like I'm starting to get some questions. So the first one, can you post your email address on the screen again? Yes, there it is. So again, my name is Rod Kight. I'm an attorney, and I represent businesses in the hemp and the CBD industry. My email address is rod@canabusiness.law, and my website is canabusiness.law. I also write a blog on issues affecting the cannabis industry at large, including hemp and CBD, and you can find that on my website. So do you have suggestions on finding trustworthy and affordable CPAs? That is a great question. There are a lot of amazing CPAs out there, just like any professional. There are a lot of factors going into it. The primary one is where you are. You know, most people like to operate with their professionals within their, particularly CPAs dealing with money, you know, that are in their region. And so it's specific to that. Looking for a CPA, you also want to identify CPAs that have knowledge and deal in the specific thing you want. Is it dealing with payroll and handling that kind of stuff? Is it filing tax returns? Is it assisting with valuations in a merger? But as far as just sort of general CPAs, I would do all the things you normally would. Google and look at the reviews. Also, feel free to email me if I have any knowledge. I'm happy to pass that on. Okay, how can we get a hold of you afterwards to ask some questions? Feel free to call me at the number or email me. There's also a contact on my web page. You can reach out, and I'm happy to answer questions, schedule consultations. Happy to do that. Okay, and also, could you speak a bit on the EIDL question? So, EIDL is the law regarding some of the grants under SBA loans under 7B2. I don't have a whole lot of information on those. I can definitely put you in touch with people who have a lot of the technical information. But your question was, is the EIDL 7B2 grant the $10,000 limit grant within 3 days while waiting for the EIDL loan, or are there other EIDL grants besides this one? The only one that I'm aware of is the $10,000 EIDL grant. There may be others, and again, I'm happy to connect you with financial professionals, CPAs, and other financial professionals who are focused on drilling down on those very specifics and can help you decide which loans or which grants to apply for and when, and make sure that you're applying for them in the right way. Let's see. Okay, I've got a great question. Rod, discuss when does a director owe duty to a company's creditors, and can that translate into personal liability for the director? Okay, that's a great question. So in other words, if there is a director of a company, either on the board of directors or maybe even an officer, and that company owes money, when can that director have personal liability for that company's loans? And just off the top of my head, that can happen in a number of situations. The most common one is when that director actually signs a personal guarantee. So if a new startup company or a young company without a lot of proof of revenue and assets goes to the bank and wants a loan, it very well may be that the bank is willing to provide that loan, but only if the directors will also agree to be to guarantee that loan. So if the business defaults, they come after the director. So that's the number one reason. The second would be when the creditor who's owed the money is able to pierce the corporate veil. And so one of the main legal reasons for having a corporate entity such as an LLC or a corporation, which is just Inc., that INC at the end of a business name, is for limited liability. In other words, when those companies are created, they're literally in a legal sense birthed into the world as new and separate entities from their owners. So a person opens up an LLC to grow hemp or to sell bicycles, or it doesn't matter. That LLC contracts with the world. It might incur debts, it might have vendors, and so on and so forth. By and large, those vendors can only sue the company, not the owner, for those debts, and it can get the company's assets if it gets a judgment against them, but can't go after the individual unless that creditor is able to pierce the corporate veil. And there's a lot of law on piercing the veil and getting through to those directors, and it has mostly to do with certain types of malfeasance and fraud, and also where a director really just uses the company as that director's alter ego. And so in all manner of dealings with the world, that director has treated the company as it's his or her self. And so in that situation, the creditor can say, no, the debt really is owed by the director in her personal capacity. And so this can occur by not following corporate formalities, such as, when on contracts, it can, or keeping up the books and minutes in extreme cases. It's also important not to commingle funds. If you're someone who has an LLC, you want to make sure that the LLC has its bank accounts and you have your bank accounts. And if you get paid, the money is transferred over and you're not just taking it from the LLC money. All of these things can create liability. And then the final one that comes to mind is certain types of tax liabilities. So for withholding taxes of most sorts, the directors of a company can be responsible for payment of those taxes, even though they're company taxes. And in fact, I believe off the top of my head that the people who are responsible for doing the withholding can be held liable. So it doesn't even necessarily have to be a director. It could be an admin person who is in charge of doing the withholding. All right. I think that hits all of our questions. I think I'm gonna just sit for just a little bit longer in case there are any other questions. And while I'm doing this, again, thanks to Chris Davis and Tom Bowden of INCBA, an International Cannabis Bar Association. I was on a webinar with them earlier this week, and I was able to gather some of the SBA information that I presented to you based on their presentation, and they did a great job. So thank you for listening. Thanks for having me. If you have any questions at all, don't hesitate to reach out to me. I'd be happy to chat with you.